Successive Conflicts of Interest Part 2. Rule 1.11 deals with conflicts involving government attorneys. Rule 1.12 deals with conflicts of interest involving former judges, arbitrators, or mediators. How do successive conflicts of interest work with attorneys in governmental settings, in the district attorney's office or the attorney general's office? The first thing to note is that Rule 1.7 applies for individual conflicts of interest exactly as it does for private attorneys. The individual assistant attorney general should not handle a case for which she has a personal conflict of interest. For example, Assistant DA Debbie should not be involved with the prosecution of her next-door neighbor or her brother. However, Rule 1.10 does not apply to disqualify the entire office of the district attorney. Rather, Rule 1.11 solely governs conflicts for government attorneys. Why this difference? There are a few considerations. First, it is assumed and hoped that individuals will, from time to time, leave private practice to join the public sector. The rules do not want to make it unduly burdensome for them to do so, nor unduly burdensome for public attorneys to return to the private sector. Secondly, as public attorneys are not simply advocates but ministers of justice, they are trusted to excuse themselves from involvements in cases for which they have a personal conflict of interest. We do not assume that everyone in the DA's office is trying to help one another out to make the most money for the firm. And finally, it would be too burdensome to conflict out the entire office each time one public attorney had a conflict of interest. While Rule 1.10 does not impute conflicts of one attorney to the entire government office, it will be prudent to screen lawyers with conflicts, as Comment 2 to Rule 111 notes. For all these reasons, neither Rule 1.9 nor Rule 1.10, which we have been discussing, are relevant to public sector conflicts. Instead, Rule 1.11 is the exclusive rule to look to for conflicts within the public sector. Let us consider the subsections of Rule 111 and how they apply. Rule 111D deals with the current government attorney. The government attorney should have no involvement in any case in which she, quote, participated personally and substantially, closed quote, before she joined the office. When Debbie joins the DA's office, she should indicate the matters on which she has worked personally and substantially, and the office will arrange that Debbie will have no involvement of any kind in those cases. The other three subsections, A, B, and C, deal with conflicts after the attorney has left government practice. Under subsection A, once Debbie DA is back in private practice, she personally is prohibited from handling any matter in which she participated personally and substantially while at the DA's office. However, under subsection B, her firm is not prevented from taking such a case. But for her firm to handle such a case, Debbie would need to be screened off from the case, apportion no fee from the case, and the governmental office immediately notified so it could ensure that appropriate screening was in place. This arrangement for screening to deal with public-private moves was in place long before the rule change permitting screening in private-to-private moves. Cases in this area will no doubt be a model for the newer option of screening in private-to-private moves. Subsection C of Rule 111 provides that a former government lawyer who knows confidential government information about a person cannot represent a private client whose interests are adverse to that person, where the government information could be used to the disadvantage of that person. This prevents the former government lawyer from unfairly advantaging future clients because she possesses confidential government information. It is also prophylactic in discouraging the government lawyer from obtaining confidential government information so that she can benefit future private clients. Rule 1.12. Briefly, Rule 1.12 sets up very similar conflicts rules to deal with successive conflicts for attorneys who have served as judges, arbitrators, or mediators. Rule 1.18 deals with conflicts when the attorney had met with a prospective client. If an attorney has met with a prospective client, she may not represent an adverse party in the same or substantially related matter if she obtained information from the prospective client that would be significantly harmful to that person. The comments suggest that the attorney may seek to limit the confidential information that she receives in the initial contact. Rule 1.18d, however, will permit the lawyer's firm to represent adverse parties if the lawyer took reasonable measures to avoid exposure to more disqualifying information than necessary, and if the lawyer is timely screened and written notice given to the former prospective client. This rule prevents unscrupulous clients from firm shopping with the goal of conflicting out all the firms in town. This comes to the end of our discussion of successive conflicts of interest, probably the hardest unit in this class. Congratulations.